Let's now welcome Professor Tshepo Madlingozi, the Commissioner for Justice, Education, Anti-Racism and Equality at the South African Human Rights Commission. Prof, great having you with us on the show. Welcome. So let's first understand the reasons as well as circumstances that actually initially led to this ruling that effectively took away your binding legal powers in the first place.
Good afternoon to you and your listeners. The source of this dispute had to do with a fundamental right, the right to water. Some farm donors came to us because a new farmer cut their access to borehole water. They came to us, basically complaining that the right to water, the right to life, the right to dignity have been violated. So we did an investigation and we issued a report saying that indeed the right to life, the right to dignity, the right to access to clean water have been violated. A few months later, we went to look at whether the court decision, report and the directives have been respected, and we found that that was not the case. So it was clear that the farmer was saying that they would not respect our decision. So we then went to the High Court in Mpumalanga to ask the court to, number one, make it very clear that the directives of the Human Rights Commission are binding and they must be followed. If you're not happy with them, you as a respondent can go to court. Mm-hmm. But secondly, to vindicate the right to water, the right to life. Now, that is at the heart of this. At the heart of this is whether the directives issued by the Human Rights Commission after a thorough investigation should be binding or not. So the Supreme Court of Appeal agreed with the Mpumalanga High Court to say our directives are not binding. I can confirm that yesterday or 2 days ago on Thursday, we did lodge papers at the Constitutional Court to appeal this decision.
Mm-hmm. And Prof, for better understanding, what type of powers did the Commission initially possess that you feel should be reinstated by the Apex Court, and what will then form part of your appeal submissions?
Yes, so the drafters of the Constitution saw it wise to create Chapter 9 institutions. These are institutions that will support democracy, the IEC, the Auditor General, the Commission for Gender Equality, the Human Rights Commission, and so forth. Mm-hmm. These Chapter 9 institutions were to be the, easy access to justice for millions and millions of South Africans who cannot afford lawyers. NGOs are overstretched, they cannot afford to assist everyone, and therefore these institutions were created. Part of our powers is to investigate complaints that we receive from the public or to investigate on our own accord. We investigate, we listen to both sides, we look at the Constitution, we look at jurisprudence, and we issue directives. And therefore, those directives were, traditionally followed. All the respondents will listen to our directives and they will, agree and implement what we said must be implemented. Those who were not happy were to go to court to contest, that kind of finding. So the effect of this decision is twofold. Number one, it says that anyone can, in effect, ignore our directives. We spend a lot of money, we conduct a thorough investigation, we hear both sides, and we issue these directives. Therefore, the effect will be that, anyone can ignore our findings. But number two, most importantly, it will mean that for millions and millions of South Africans who rely on the Human Rights Commission, they will have to wait for years and years for a court of law to agree to our recommendations. And that means that, we receive about 6,000 complaints a year. Mm-hmm. It will mean that for each and every one of those complaints where we find a violation, we'll need to go to court. That is not redress.
Mm-hmm. All right, Prof, thank you so much for your input this afternoon. Certainly, we should be keeping track of what transpires at the Apex Court. That is Professor Tshepo Madlingozi, the South African Human Rights Commission Commissioner for Justice, on their appeal to the SCA judgment that basically takes away its binding powers.